Hearing the appeal RFC 2012 plc, formerly Rangers Football Club plc, against Advocate General for Scotland.
Mr. Thornhill.
My Lord, in this appeal, I appear with my learned friends Dunlop, Studer and Bremner for the appellant, and for the respondent, the learned friend Mr. Ghosh, Mr. Herbert, Mr. Goldsmith and Ms. Belgrano appear. Can I divide what I have to say into 6 sections and perhaps warn your lordship in advance what they are, so you have some idea where we might be going?
Thank you.
Section 1, which is very short, is to isolate the issues in the order in which they are going to be dealt with. Section 2, identification of salient facts. Section 3, the statutory legislation. Section 4, the case of Heaton and Bell. Section 5, other relevant cases. And 6, I hope, a conclusion.
Thank you very much.
My Lord, the importance we submit of those areas is number 4, Heaton and Bell. In our submission, that case provides the answer to the main issue in this appeal. And so that particular section will be one on which I will spend probably far more time than the others.
That's very helpful, thank you.
Going back to the issues, as your lordship will be aware, there are 3 issues now current. Isolating them shortly, issue 1, when Rangers Football Club paid sums into what has been referred to as the principal trust, which were then appointed onto a subtrust for the benefit of family members of an employee.
Yes.
Was there either A, on payment to the principal trust, or else B, on appointment to a subtrust, a payment of emoluments or earnings? As your lordship knows, the terms changed halfway through the period under appeal, of the employee. It's put both ways round. It could be the payment into the principal trust, or it could be the appointment onto a subtrust. My Lord, that's issue 1. Issue 2, as I understand it, only arises if the answer to the first question is no. And the issue there is whether the powers of the relevant employee as protector of their subtrust, were those powers such that the property in the subtrust became unreservedly at the employee's disposal, and so became his emoluments or earnings.
Yeah.
So that concentrates on the powers of the employee as protector. And my Lord, finally, issue 3, again, only arises if the answers to 1 and 2 are no. Did the placing of cash in a subtrust give rise to a taxable benefit in kind on the relevant employee under the general or residual, sometimes called benefit in kind charge, which is either in section 154 of ICTA 1988 or section 202 of ITEPA 2003. My Lord, those are the 3 issues. As your lordship realises, and I don't need to state the obvious, on issue 1, the taxpayer succeeded in the first-tier tribunal, upper-tier tribunal, and lost in the inner house and now appeals. On issue 2, the respondent has lost at every level below and now cross-appeals to this court. Issue 3 is something of an interloper, in that there have been mentions of benefit in kind charges in the courts below from time to time, but the point has never been argued. So it comes before your lordship's court for the first time. And I apprehend leads to two major questions. Should it be raised now, and is it correct? Now, what I propose to do, with your lordship's permission, is to address the court on issue 1 and briefly on issue 3, the benefit in kind point, and that will last until 12:30, I believe. Then it's proposed that the respondents deal with all three issues, that they have to make the case on protectors' powers and elaborate their case, if your lordship wishes them to, on benefits in kind and issue 1. And then tomorrow at 12 o'clock, my learned friend Mr. Dunlop will reply on issue 2, the protector issues, and I will finally reply on issues 1 and 3. And my lord, that's the proposed course, but your lordship may have other ideas, but...
Well, I think the sensible way to proceed is for you to proceed precisely as you said. We'll hear then, from what you say, Mr. Ghosh, opening his respondent's case on behalf of the respondent. We'll then have time to discuss over the short adjournment whether we're happy to proceed as you've suggested. But certainly for this morning, what you've suggested sounds very sensible.
I'm very grateful.
Thank you very much.
Well, Lord, that finishes part 1. I now proceed to part 2, the facts. Since this is an issue, and facts I'm addressing particularly on issue 1, and as your lordship will see, issue 1 has become an issue on what might be called the redirection of earnings. And in essence, the difference between the two sides is that we submit you cannot redirect that to which you have no right, whereas the inner house said entitlement was irrelevant. You can have a redirection of earnings even where there is no entitlement. That being the issue between the parties, I would direct your lordship very briefly to some of the key salient findings of fact. And could I start with the first tier tribunal at paragraph 232, which is MS 317. It's a paragraph beginning our findings of fact.
Yes.
Do I need to read it, my lord, or because it's sufficient to ask your lordships to read it?
That's fine. We can read it. Thank you very much.
The essential point is that there was no underlying tacit agreement to pay earnings absolutely. And that's preceded by paragraph 231, same MS page, where as it begins, the trust loan scheme is essentially straightforward, and that the loan is the extent of the employee's benefit. And those findings, we say, are crucial because they negative any question of entitlement on the part of the employees in question, and therefore give rise to the issue, can you redirect earnings where there is no prior entitlement to them? Now, in paragraph 232, to which I've just referred, the tribunal then refer back to paragraph 103, that is on MS 283.
Thank you.
I don't ask your lordship to read that because it sets out the basic facts. And the basic facts have been set out in the statement of agreed facts and issues. And I don't suppose your lordship wants to go through all the detail. However,
is there any particular fact you want to draw to our attention?
Yes, but the critical point is that there are two kinds of employees involved here. there were footballers and some footballing executives on the one hand, and on the other hand, there were executives. And the situation with regard to the two of them is not the same. The difference becomes clear if one goes forward to paragraph 205 of the first tier tribunal.
Thank you.
That is a critical passage, and that is found at, I just lost the reference now,
311.
311.
Thank you. Yep.
And that's a critical passage because what emerges from it is that the executives had simply, if I can put it this way, a possibility of being considered for a discretionary bonus. The amount of the bonus and the form it might take being at the discretion of the employer.
Yep.
So prior to a decision being made by the employer, there was no entitlement on their part. And that is the point which emerges clearly in our submission from that finding in paragraph 205. We accept, they say, that these were entirely discretionary with no contractual entitlement. Of course, it's possible in that sort of situation for the employer to have a consultation with the employee beforehand as to what kind of form the bonus might take. There's no reason why that shouldn't happen. That doesn't give rise to any contractual right. It simply explores possibilities, and that did happen in this case. But while the executives are covered by paragraph 205, the footballers, and actually some of the footballing executives, are covered by paragraph 206 to 208.
Can you just explain the sentence in 205? We consider that the benefit falls within Mr. Thornhill's description of a mere discharge of an employer's obligation to an employee.
Yes, this is a term which appears fairly frequently in the first tier's findings. I have a suspicion that it's interloped by mistake, because having searched where the expression discharge of an obligation first came from, it seems to have arisen in the context of what amounts to payment for pay-as-you-earn purposes. And I think it may have been Lord Hoffman who said payment can sometimes mean discharge of an obligation, but it doesn't mean that for pay-as-you-earn purposes. It means a cash payment. Then it seems to have crept across into this area. So quite what the first tier tribunal...
You're saying we should just ignore that sentence.
Well, I wouldn't say I'd ignore it, but I mean, they're clearly saying there was no pre-existing contractual right. If there's no pre-existing contractual right, it's difficult to see how one could be discharging an obligation, because there's no obligation to discharge.
That's what I didn't understand.
But the important sentence you say is in the third line of that paragraph.
Yes, absolutely.
And this doesn't detract, you say, from that sentence, Lord Carnworth.
If it helps, I mean, the sort of thing which would be a discharge of an employer's obligation could be an obligation to make a contribution to a pension scheme, which might well be contractual.
Yes, quite.
And therefore, there's a discharge of an
But
obligation.
the fact that it's a discharge of an obligation doesn't add to or subtract from
quite
the
so,
finding you rely on.
Yes, giving a sensible interpretation.
Okay.
That's what we say.
Thank you.
Now, by contrast,
Yep, you were taking us to the next
if we
few
go to
paragraphs.
paragraph 206,
Yes.
onwards to 208. There's no doubt whatsoever that with the footballers and the footballing executives, there was a contractual obligation. It may be important to ascertain precisely what it was, and it might be sensible to take the court to an example of one of the letters written to footballers. Could I ask the court to turn to MS 675? This is an example of one of the letters concerning a Mr. McCann.
Thank you.
And again, could I ask the court to read it, and then I'll comment on it.
Yes, thank you.
So what we have in my submission is a contractual promise, which is the second short paragraph, to make the funding available to the principal trust. And then that's followed by a recommendation to create a subtrust, not actually a contractual obligation, and a recommendation that there should be a loan.
Yep.
So there were these differences, therefore, between the two classes of persons. And I pause at this stage to point out that so far as the executives are concerned, although there might be talk of this being a marketed tax avoidance scheme, I mean, that term has appeared in argument, the position of the executives, in my submission, is one which one could find up and down the country with many family private companies where there's no formal bonus procedure and it's handled in the same informal way as appears from paragraph 205 of the first tier tribunal. Mm-hmm. It's a very common way of doing things. And the result we submit is quite simple. If the bonus takes the form of cash, then it's earnings or emoluments. If it takes the form of a benefit in kind, then it may or may not be taxed under the benefit in kind provisions, and it may or may not involve a liability to pay as you earn. It simply depends on what actually happens. The footballers, by contrast, did have a contractual right, and it may be asked, does that make any difference? We submit not. In many instances, an employee may have a contractual right to receive a benefit in kind. A good example would be an obligation to make regular payments into a pension scheme, either an approved one or an unapproved one. There would be a contractual obligation, but that doesn't mean that there's earnings or emoluments. Quite the contrary, there aren't any earnings or emoluments, and I'll elaborate that point later.
Yeah.
What matters, we say, is what the employee gets. What does not matter is what a third party gets. My Lord, that's sufficient, I think, on the facts. So that ends part 2 of what I had to say. At paragraph 205, there is a reference to the case of Heaton and Bell.
Yes, there is.
And if your lordship wants to pursue it, it was clearly a case which the first-tier tribunal had in mind because it paragraphs 127 and 139. I won't ask your lordship to refer to it. The chairman specifically mentions Heaton and Bell.
Yes.
In my submission, this was the late Mr. Muir, he was quite right to do so. It is a case which resolves a lot of the issues which are before the court today. But before I go to it, perhaps I should show your lordship the statutory provisions in ICTA 88 and in TEPA 2003, which deal with earnings and emoluments.
Yes.
So can one start at MS 1202, which is volume 1 of the authorities, division 5,
Yeah.
and at page 1202 comes the charge on emoluments,
Yes.
which I can read very quickly. Tax under case 1, 2, or 3 of Schedule E shall, except as provided to the contrary by any provision of the Tax Acts, be chargeable on the full amount of the emoluments falling under the case, subject to such deductions only as may be authorised by the Tax Acts, and the expression emolument should include all salaries, fees, wages, perquisites, and profits whatsoever. Pausing there, my lord, those words have survived almost unscathed in the Income Tax Act of 1842. They first went to the 1918 consolidation, then 1952, then 1970, and finally appear in the 1988 Act. I make that point because the learning in the cases is very often under the predecessor provision, so it's important to bear in mind that they have retained their character over a very long period of time. Your Lordship will no doubt comment that there really isn't very much guidance in that simple provision as to what are emoluments or earnings, except that definition. To find out what are emoluments, one has to go to the case law, and the case law is summarised very conveniently in my submission in Heaton and Bell. Which
am I right in saying that looking at the statutory provisions, there is nothing express to support the proposition that the employee must be the recipient? We get that, you say, from the case law.
No, my lord, there's nothing which says that, and indeed, this anticipates a later point. The question may arise, what happens if the employee, let's put it this way, arranges that a third party receives what he would otherwise be entitled to? And there's nothing in this section which tells you the answer to that question. The answer is given in Heaton and Bell, that is to say the employee still remains a taxable person. And under the successor legislation in ETEPA, it's made absolutely clear that the employee is a taxable person and no one else.
Yes, but that is on the basis, as I understand it, that the employee is initially entitled to it.
Yes.
And he redirects it.
Yes.
But is there anything in the legislation which says if I am offered a salary of £50,000 at the outset and say, I don't want to contract on that basis, I want to receive £25,000 and give £25,000 to my mother, so that my contract says I have an entitlement to £25,000, and the employer contracts to pay £25,000 to my mother, that would, on your approach, the £25,000 to the mother would fall outside the tax charge.
I'm not sure that it would, my lord. I'll deal with that point when I get nearer Heaton and Bell, but in my submission, that is not the result. I don't necessarily have to answer that conundrum.
Well, it is rather central to your proposition.
Not in my submission, because that's a more extreme case than one has here. Nevertheless, it will be sensible to address it, and I will, as to what the answer is. Now, this legislation applies for the first 2 years under appeal, 2001-2, 2002-3. Then it was superseded by ETEPA, a special act dealing with employment income and pension income.
Where do we find that?
And, well, before we go there, I should point out that ETEPA was not a consolidating act. Therefore, it might be helpful, and it is set out in the appellant's case, to look at the notes for guidance presented to Parliament to show exactly what the draftsman was trying to do.
Very well.
It's a very short passage. I can refer to it very quickly. If your lordship would turn to MS 78, part of the appellant's case.
Righty-ho. Right, yes. Yes, thank you.
There is a quotation, an extract there from the notes. Perhaps I could ask your lordship to read it and save myself reading it out.
This is the italicized, note 13.
But it essentially makes clear, my submission, that the draftsman was trying to modernize the language, but not change the law.
What a dangerous thing to want to do.
Yes.
Well,
Some might say it's getting close to being a
well,
contradiction.
emoluments, my lady, I suppose it was a bit of an old-fashioned thing, and perquisites. I mean, if you went out in the street and talked about perquisites, I don't think most
If
people...
you talked about perks, everybody would know what you meant.
Yes, well, anyhow, for better or for worse, that was what was attempted.
Right. Apart from one significant departure.
And the resulting legislation, after you've read that, comes at MS 1285. That's to say, Volume 1 of the authorities at Division 9.
Thank you.
Was this all, this is all part of the tax modernisation project?
Yes, that's right, yes.
The grand scheme to make it all, bring it all up to date.
And the resulting section, which we need, is section 62, which is actually MS 1311.
Thank you. Yes, earnings.
And one can see, I think, if one reads section 62.2a, looks like the past, salaries, wages, or fee, and then perquisites becomes B, any gratuity or other profit or incidental benefit of any kind obtained by the employee if it is money or money's worth. And then money's worth is defined in subsection 3, something of direct monetary value to the employee or capable of being converted into money or something of direct monetary value to the employee. The definition of money's worth follows very closely, I would submit, Tennant and Smith, a very old tax case. What is made clear is that, going back to 62.2b, that any gratuity or other profit or incidental benefit has to be obtained by the employee, and if it's money's worth, it's got to be of direct monetary value to the employee, either under 3A or 3B.
Right.
So that part, the words obtained by the employee and monetary value to the employee are something new, which wasn't, but it was part of the existing law, but it's simply made much clearer in section 62. And we would submit that the qualification in 62.2b obtained by the employee would naturally go also with salary, wages, or fee, because salary, wages, or fees are normally obtained by the employee. Now, to go back to my Lord Hodges' question, one might well question if I arrange for what would have been part of my salary to be paid to a third party, it might well be said that the negotiations leading to that result, in fact, are are something which could be described as obtained by the employee, because clearly the employee has got to be involved in the process if he is going to arrange for what would be his earnings to be passed to a third party.
Well,
Might depend
I
on
wonder if that
facts.
helps you, because you have a side letter from Rangers to the employee saying this is the scheme which is part of your total package, in effect.
Yes, but my lord, if that proposition is as correct, it's as simple as that, then the immediate effect is going to turn many, many benefits in kind into earnings or emoluments. I mean, if I say to my employer, I would like to have a good pension provision, I want you to undertake to make a contribution to the pension scheme for my benefit. Why shouldn't it be said, well, on the same reasoning as the Inner House presented, there is money or money's worth. Clearly, it's part of the employment package. It's going to the pension fund, but you've arranged it, so why isn't it your earnings? And
Well, that was the difficulty which was raised in relation to national insurance
Yes,
contributions
indeed.
in Ford and McHugh.
Yes.
Yes.
And as your lordship was well aware, the result of that case was it was held not to be earnings, even though the concept of earnings for NIC purposes was wider than the concept of earnings for income tax. And that result, the result in Ford and McHugh would follow in our submission for income tax purposes, and that's that.
But I think in Ford and McHugh we were careful to indicate we were not making a ruling on the meaning of emoluments.
You were, and your lordship also pointed out that there was no argument presented along the lines of Smith and Stretton.
Yes.
But of course, in Smith and Stretton, and we'll come to that case in a minute, it's the Dulwich schoolmasters case, they were entitled to an increase of salary, and the salary was employed in making contributions to a scheme. So not surprisingly, they were held to be taxable because they were entitled to the increase. It was part of their package.
Thank you.
Well, that's the legislation. I pass now to part 4, which is Heaton and Bell.
Yep.
Now,
I suppose, I mean, it occurs to me also that in Ford and McHugh, because you were dealing with a pension, there was going to be a receipt by the employee directly at a later stage.
yes,
So to avoid double taxation, one had to choose between the taxation of the contributions when those were made as earnings on the one hand, and the taxation of the pension when it was actually received on the other hand, and the latter was preferred on the footing that the pension was, when paid, a form of deferred remuneration.
my lord, that's quite so. But of course, it's also important to bear in mind that here we have the creation of a subtrust, a loan being made from the subtrust. Now, pausing there, the loan was clearly a taxable benefit in kind. Secondly, there are complex provisions to which I will demonstrate to the court, dealing with what happens to loans. If, for example, they're written off, then you've got a charge to income tax. If they're released, there's a charge to income tax. Even if they're released after the employment has ceased, there's still a charge to income tax. If the original loan is replaced by another loan and that loan is written off, there's a charge to tax on that. So it isn't as though there being no charge to earnings on day one means that the income tax field is free, so to speak, forever after. There are plenty of ways in which tax charges could arise. And it's still notable, I make this point really in relation to benefits in kind, that the only benefit in kind which the respondents are seeking to find tax on is the general residual charge. But there are complex provisions dealing with loans. those provisions actually take precedence over the general charge. And yet, despite all that, despite the fact the point has been alluded to on many occasions below, no attempt has been made to collect tax under that head. So, my Lord, if it said, well, it all looks rather good, there's no tax on earnings, the real answer is if the revenue authorities had pursued the benefit in kind charge on loans with all its attendant extra charges, there were plenty of ways in which income tax charges could have arisen.
Yes, I see. Thank you.
Thank you.
Now, Heaton and Bell is, lost the reference to it now, in,
Volume 2, tab 21.
oh, thank you very much. It's volume 2 of the authorities, tab 21, that's at 1832 of MS.
Yeah.
Now, this case arose under the legislation which was at that time the Income Tax Act 1952 and the Finance Act 1956. But as I explained earlier, it's not materially different, so there's no issue on that. The essential facts can, I think, be got from the first 2 paragraphs of the head note. Would your Lordship prefer me to read them?
Yeah,
Or?
that's fine. The first 2, yes. The italicized head note, yeah.
And your Lordship will notice that the employees were earning under £2,000 a year. That was then the limit for the benefit in kind charge. So no benefit in kind issues arose in this case. It was simply emoluments. And
Yeah.
if your Lordship read that, then could I ask your Lordship to go to page 216, that's MS 1837. This is a letter to the employees from Waddington's, the employer, and if you were to read the second 2 sub-paragraphs of that letter,
The present wage adjustments.
that's right, yes. And you can see, and this is maybe of some importance, that costs were being incurred by the employer, not surprisingly, in providing the benefit of the car scheme. So payments were being made to third parties for insurance, motor tax, and of course the purchase of a car as well.
Yes.
Now, going to the House of Lords, Lord Reid starts at page 243. And the first question he decided that had to be dealt with was the entitlement of Mr. Bell. Was he actually entitled to an unreduced salary, which was then being applied in a certain way, or had his salary been reduced and replaced by a benefit in kind charge? And we see that if your Lordship went to page 243, just below the letter D, picking it up there, the Commission has held that the use of the car is not, in our view, money's worth, and that therefore these sums were not part of the respondents' emoluments. Their decision was reversed by Mr. Justice Angoy Thomas, but restored by the Court of Appeal. Then he continues, the first question to be decided is a true construction of the agreement made between the respondent and his employers when he came into the scheme. And perhaps I could ask your Lordship to read the paragraph E down to H.
This is a dissenting judgment, is it? Dissenting speech.
Yes. Oh, no, well, yes. everyone agreed that this was the question to be answered,
Right.
but Lord Reid answered it in a different way from everyone else.
Right.
That is important. The other 4 members of the House decided that the salary had not been reduced, but Lord Reid said it had.
Right.
But that doesn't really matter, because you can see from that paragraph, just above the letter G, an important sentence. What he chooses to do with the wage or salary to which he is entitled is of no moment. But the respondent says that is not what the parties agreed. He says he agreed to accept a reduced wage, and that as a counterpart, his employers agreed to give him the use of a car. If that is right, then he became entitled to 2 things. First, the reduced wage, and secondly, the use of a car. The point I emphasize, a very simple point, not very complex, is that first and foremost, what was the employee entitled to? What was his salary? If he was entitled to the salary, then if he dealt with it by allowing it to be used for an agreed purpose, he was still taxable. We say here, if the employees were not entitled, the fact that various benefits accrued to them means that it's not part of their emoluments or earnings. It may well be a benefit in kind, but it's not part of what they're entitled to.
But there only was, in this case, one recipient, namely the employee. And the question was, in this case, was it wages or was it perquisites and profits? This case is not addressing the circumstance where the agreement between the parties at the outset involves some sums coming to the employee and some sums going to others.
Well, my lord, I would respectfully disagree. Whatever comes to anyone in this particular appeal still comes to the employee. It comes in a mixture of salary and a mixture of benefits under the trust arrangement. I mean, whether that happens ab initio or whether there's a change in the middle of a contract can't affect matters.
No, but the first-tier tribunal focused on the receipt of the loan by the employee. The inner house has looked at the payment of the sums for the benefit of the family, which then gave rise to the loan. And the focus has moved from what the employee got to whether or not a payment at the request of the employee to the third party, which was part of his reward for his services, was an emolument.
Well, my lord, the focus undoubtedly moved. We say it moved wrongly, because if you take that point of view, what happens if in the negotiations for the contract, if I go back to the pension example, the employee says, I don't want to be paid 100, I'd like to have 80, and I'd like 20 to go into a pension scheme for myself and my family.
Yes,
now,
that's a question I'll be asking Mr. Ghosh.
Well, he gets the benefit, and his family does, but he doesn't receive money or money's worth. In the present case, it's exactly the same. The footballers were persuaded. I mean, it took some persuading and explanation, because let's face it, all they got was a loan, which was held to be a repayable loan. So sooner or later, something had to be done to get it repaid. They got that benefit. The family got the benefits, so far as there was a benefit, not very much, I suggest to begin with, of having a trust fund. But no one got money or money's worth except the trustees. But one doesn't look at the trustees any more than you look at the trustees of a pension scheme. They're trustees. So that was Lord Reid then considers the answer to that question. And as your lordship pointed out, he agreed that the entitlement had been reduced. But the fact that he dissented on that point doesn't alter the fact that he was looking at entitlement. And his conclusion on that point comes at the top of page 245. Now, I won't take any more of Lord Reid at this stage. I would just point out first that Lord Morris did exactly the same performed exactly the same process. So we find that at page 248, which is 1869, at the second break, where he says it's necessary in the first place to decide as to the true interpretation of the agreement subsisting at the relevant time. When he joined the car loan scheme, did he vary his terms of employment by agreeing to accept a reduced wage, etc.? So he's looking at the same question of entitlement. He then considers it at considerable length, and conclusion arises on page 253 at 1874, where he says, for the reasons I've set out, the monetary wage to which the respondent was entitled, again I emphasize the word entitled, remained unaltered. So he disagreed with Lord Reed, and the other members of their lordship's house took the same view as Lord Morris. Lord Hodgson, at page 257, that's MS 1878,
Yep.
considers the same point and arrives at the same conclusion. You see it very clearly between the letters D and E. I do not think any other conclusion is to be drawn from the ambiguous phrase amended wage basis. The basis was not amended, it remained the same throughout. The variation which took place during the operation of the scheme was in the amount applied by the employee out of his wages. Then Lord Upjohn, later at page 258, 1879, at the first break in his speech, the questions that arise upon this appeal are, one, whether upon the true interpretation of the contractual arrangements made in 1961 between the respondent and his employers, the monetary wage which the respondent was entitled to remained unaltered. So that was the same question. He answers it at page 259 at the third break, just below the letter G. In my opinion, with all respect to the judgments in the courts below, I think it is clear that the legal result of a transaction between the parties was that the respondent was agreeing to a retention or deduction, or if you like, a reduction in wages earned by him and clearly due to him in cash. So entitlement remained. And then Lord Diplock.
Lord Upjohn goes on to, it's just towards the end of that page, to emphasise the need to look at the real nature of the transaction. And
Yes, so
over the page says you can't disguise it by using camouflaged.
page which
Over the page,
Yeah.
just over the page, top of 260.
Yes, dress it up how you will. I hope a court won't be deceived by the disguise, he says. He's not talking about a sham, but he's talking about considering the real nature of the transaction rather than the form it takes.
Yes, I've lost the passage your lordship's referring to. Is it at
Top of 260.
the top of?
260, top of 1881.
Yes, yes, certainly he talked about the real nature of a transaction, yes. And I think he had a quarrel with some words of Mr. Justice Rowlett, who in one of the earlier cases, perhaps as a counsel of despair, said, oh, well, it's all a matter of words. It's how you draft the contract.
Yes.
And Lord Upjohn, I think, was a little reluctant to think it was just a matter of words.
Yes.
But if I may say this, the first-tier tribunal didn't shirk the task of looking at the real arrangement. I mean, they spent a very long time listening to prolonged cross-examination to determine exactly what the parties did agree or not agree. So that they were looking, in my submission, at the essence of the arrangement and not at some attempt at clever drafting to achieve a result. And then Lord Diplock, perhaps it's pick it up very shortly at page 261, 1882, the bottom of the page, the letter I, I agree with those of your lordships who are of opinion that the only proper inference to be drawn from the facts and documents relating to Mr. Bell's participation in the car loan service which are disclosed in the stated case is that the agreement which he made with the company, collateral to his contract of employment with them, was that he should pay to the company a weekly sum for hire of a car, and that the company should deduct and retain that sum out of his weekly wages. So he agrees with the others. So, pausing there, all members of the House, in my submission, started by asking what was the employee entitled to. Because if he gave up his right to the salary, or part of it, and instead said, I want the benefit of the car scheme, he would have reduced his taxability on his salary because he would have ceased to be entitled to it. If, on the other hand, he remained entitled to his salary, he was agreeing that his salary be applied in a particular way for his benefit, and he remained taxable on it. And we say the first-tier tribunal and upper-tier tribunal got the law right in this respect, and that the inner house, in saying that entitlement was irrelevant, we would respectfully say erred in law. But that is what they did say, and it's perfectly clear that they said it. If I can take your lordships to the inner house's decision, at the passage around paragraphs 56 to 62, that point is made very clear. Paragraph 56 is MS 204.
Thank you.
Because they say there, the fundamental principle that emerges from these cases, I'll go to these cases later.
Thank you.
It appears to us to be clear, if income is derived from an employee's services qua employee, it is an emolument or earnings and is thus accessible to income tax, even if the employee requests or agrees that it be redirected to a third party. That accords with common sense. Stopping there, of course, that would accord also with my submissions. If when you say the employee requests for income to be redirected to a third party, yes, that's quite right, but he can't redirect it if he's got nothing that he's entitled to. Then there's the loophole, which I'll address later on. And I think the point is re-emphasized in paragraph 59. In the passage a few lines down, first in relation to employees other than footballers, the critical element is that bonuses were paid on the basis of the work performance of the employee in question, qua employee, and the profitability of his employing company. Thus, the amount of the bonus was determined by reference to the employee's employment. While the bonuses were discretionary and there was no contractual entitlement to them, it is very obvious that they were derived from and based on the work done by the particular employee. Of course, no point is taken on that. Of course, the money derived from the work. That's not the question. The question is, was there entitlement? Then, perhaps most clear of all, paragraph 62, MS 208, as will be apparent from the foregoing discussion, we are of opinion that it is immaterial that there was no contractual entitlement for sums paid to the trustee of the principal trust, and then gratuities are subject to income tax and so forth. We say that's irrelevant because gratuities are normally received by the person who's meant to have them. One doesn't redirect them. But that's a clearer statement, I think, of the fact that entitlement is irrelevant.
So you say, if essentially, you would put it this way, that this is tilting at a windmill, that this is not dealing with the point that's really at issue.
No, it isn't. I mean, it begs the question.
Right.
The whole question is entitlement necessary? And we say, well, it is, because if it isn't necessary, surely to goodness, all those passages which I've been quoting from the speeches in Heaton and Bell were beside the point. I mean, there was no doubt whatever in Heaton and Bell that money was being paid to third parties to produce this car scheme. If you said, did that money arise from the performance by employees of their services? Of course it did. It was part of their package that they could participate in this scheme.
So does it come to this? If my employee says, I'm very pleased with what you've done, I'm going to give you a large sum of money. If my employer says that to me.
He says,
I'm very pleased with your work.
Yes.
I'm not obliged to pay you extra, but I'm going to give you this money. Then it's not taxed.
Not, well, it would be if he gave it to you.
So
if he
gives
said,
it to me, it is taxed, but he gives it, says, I'm very pleased with what you've done, I'll give money to your wife or husband. That would not be taxed.
well, that would be actually, because that's clearly a benefit in kind, because it's paid to members of a family, member of a family.
If it's
It
paid to,
becomes less clear, and I entirely accept that there clearly is a difficult area where the employee persuades the employer to make some payment, perhaps, to a third party who isn't a member of the family, that's not therefore a benefit in kind.
it's not payment of a debt or something like that, the employer.
No. Let's
That would be
suppose
different, quite.
it's a simple outright payment to a third party.
But if you say, well, a friend of mine has fallen on hard times, I know you want to give me an informal bonus, give it to my friend who needs the money. That would then be...
Well, I'm not sure about that. You see, I think, in a sense, that's a further question which sooner or later someone is going to have to answer.
But I'm asking you to answer.
Well, I know you are, yes, but you don't have to answer it. In this case, or you can say quite clearly in my submission that the employee is the beneficiary of the arrangement. It's simply that he doesn't receive the money absolutely. He gets the benefit of loans and having a family trust fund. Now, what the position would be if an entirely separate third party received the money might depend on the facts. For example, if there was any arrangement, for example, that the money was going to be handed back to the employee, I mean, clearly the courts would see through that, one would suspect. If, on the other hand, and this has happened in practice, let's say an employee performs some exceptional piece of work and says, I don't want to be paid, I simply don't want to be paid, but if you appreciate what I do, you might like to give some money to my favourite charity. I mean, that is something which, in my submission, is well recognised as not giving rise to a tax liability.
Because it's to a charity.
Because?
It's to a charity.
No, it's because the person in question is saying, I do not wish to claim anything whatever, but if you feel that I've conferred a benefit on you and you'd like to do something that I would like to see done, give some money to my charity, that certainly has been accepted in my professional experience as not giving rise to taxable earnings on the employee, and reasonably enough.
Well, getting back to the case law, you're putting a lot of weight on Heaton and Bell. Now, no one was doubting the only person entitled to either the salary or the car was the employee. And what Heaton and Bell was about was which box do you put the entitlement into? Is it a wage? Is it a perquisite? To be a perquisite, it had to be, the car entitlement had to be convertible into money, as I understand it.
Yes,
because you could surrender the car for money, it was a perquisite.
Yes, if it
And
hadn't been for that.
the case didn't remotely address the circumstances we're dealing with today. Well,
my Lord, I would submit it is, because the the employee in Heaton and Bell became the beneficiary of the car scheme, and let's suppose he had reduced his salary, because of course, as he didn't, the point didn't arise. But if he had reduced his salary, he did so and arranged that he became the beneficiary of the car scheme. In this case, the employee agrees to take part of his reward in salary and part as a person who could benefit from a trust fund set up by the employer.
He could benefit and his family could benefit, because on his demise, the loan, if made, would have to be repaid to the trust fund together with interest if the interest was charged.
Yes, well, there was an interest charge here.
But not in fact paid. I think it was that
Not-
fact. The charge, the interest was not passing after the event from the footballers to the trustees.
It was the interest element here was payable when the loan was repaid.
Yes.
It was paid at the back end. So
That's right. So
Yes.
if the loan was repaid, or if it was continued
yes,
again and again, as it could be, then it would be repayable on the death of the employee
yes,
to the trust for the benefit of his family.
yes.
Yes.
So the position was that the employee had secured a benefit to his family.
Yes.
But in my respectful submission, that's no different from saying he's bargained for money to go into the pension fund and for money to be made available if he dies prematurely to his family. It's a benefit to his family, true, but it's not money or money's worth coming to him. So, in my submission, Heaton and Bell is a highly relevant case. If I may respectfully say so, there's no real difference between the employee in Heaton and Bell and the employees here. The employees here became able to benefit through loans, and their families able to benefit from the sub-trust. And just as in Heaton and Bell, there were the benefits of the car scheme, which came admittedly to the employee. But I mean, if his family had been allowed to use the car, that wouldn't have made any difference in my submission. Now, the second part of Heaton and Bell, if I can stay in the case, deals with the question of what would have been Mr. Bell's position had his salary been reduced. And so, if I may, I'll go back to Heaton and Bell to deal briefly with that point. It's again at volume 2, divider 21, and this time I can go straight to Lord Reed. And your Lordship will recall that at the top of page 245, he concluded that the salary had been reduced.
Yeah.
So he then carries on. If that is right, then after the agreement...
Could I have an
1866.
electoral?
Oh, yes, I'm so sorry.
1866.
1866.
Thank you.
If that is right, then after the agreement was made, the respondent was entitled to two things, the reduced wage and the right to use the cars. It is then necessary to consider whether that right was taxable. Now, his lordship then goes through the various acts, showing, I think, as I pointed out earlier, that there is substantial continuity from 1842 to 1988. Then he goes to Tennant and Smith and summarises the conclusions there of their lordships.
Yep.
Now, possibly I should ask your lordship to read that passage or scan it quickly.
What, the bottom of page?
Well, it's the history, the whole history of the test of money or money's worth.
What do you
Your
want to do?
lordship
You
may
want
well-
to go to the first break of paragraph, the following page?
Yes, if you go up to 246 at the first break.
Okay, if you want to sit down while we read that, that
Yes.
would be fine.
Well, So at that break, he then goes on to consider the meaning of the word perquisites, and
Not a word about which you can say the ordinary meaning is. Yes.
yes, and then he rejects the idea that it's that you can attribute a market value to it. In the middle of that paragraph, he refers to a case called Wilkins and Rogerson. That was the second-hand suit case, where the employee was able to go to Montague Burton and say, I think I'd like a suit, but he wasn't liable to pay for it. The employer paid for it, and the employer paid, I think it was £15, but it was agreed that the value of the suit, if you sold it second-hand, was £5, so the money or money's worth was £5 and not 15. Quite an interesting case in my respectful submission, because of course there was a payment of £15 to Montague Burton by the employer. And if someone had said, was that a payment which arose from the employee's employment, the answer would be yes, it did. It was a generous gesture by the employer to his employees, but no one took any account of that. You looked at what did the employee actually get himself. Was it money or money's worth? So in my submission, if one looks at Lord Reid, and it's the same with the other members of the House, in ascertaining the question, is there money or money's worth, he's looking at what the employee gets. Any payments made to third parties, however much they might arise from the employment, have got nothing to do with the matter. But finally, Lord Reid decides that there was money or money's worth because of a surrender right. Well, that, of course, isn't relevant to discussion today, so I needn't read page 247, where he decides what the money value was. Lord Morris, in my respectful submission, performs exactly the same exercise on page 253 at MS 1874.
Yep.
You see him referring, I don't think I need ask your lordship to read this, on page 253 at the bottom of the page, Tennant and Smith comes up again, and there's a reference to Abbott and Philbin, which was a case on options. And then over the page, there's a further summary of Tennant and Smith and of Abbott and Philbin. And then he concludes, and I think this summarizes it properly, at page 255 at 1876, the principles laid down and recognized in the two cases in this House were, I think, correctly applied in Wilkins and Rogerson. That was the suit case. The opportunity to acquire the suit of clothes or overcoat or raincoat could not be assigned or sold, but the suit, when received, could be sold. In that way, the perquisite could be turned to pecuniary account, i.e. it could be turned into money. And then he then decides...
So if the perquisite is you or anybody of your choice can have a suit, that would be £15. But if it's only you can have the suit, then it's £5 because you can't assign the right to have the suit.
Yes, quite.
If
you could,
once
yes,
you've got it.
that's right.
Okay.
Absolutely right, my lord. Yes. It's a case which is often cited to show, I suppose, the narrowness and artificiality of the emoluments charge. But there it is. That's the position. Of course, the position was changed when benefits in kind came in. Now, Lord Hodgson, I don't think I need detain your lordship much on that. On page 258
Yes.
at 1879, the same case is Tennant and Smith, Abbott and Philbin,
Yes.
and Wilkins and Rogerson. But the only point here is that Lord Hodgson didn't accept that there was money's worth. He said that if you surrendered the right and regained your salary, that didn't reflect the value of the right. It was something different. That comes at just below the letter D. He could give it up, but that appears to me to be a different thing. I'm in agreement with the unanimous judgment of the Court of Appeal on this point. Then Lord Upjohn at 260 deals with the second point, so in my opinion the second question doesn't arise, but as it has been the subject of some judicial conflict of opinion in the courts below, I make some observations on it. And then he quotes quite a long passage from Lord Radcliffe in Abbott and Philbin, where again he summarises Tennant and Smith, but I don't detain your lordships with that. What I think is clear, and it really is a simple point I make, is that all their lordships were looking and testing whether there was money or money's worth at what the employee got. The fact that money was paid to a third party was completely irrelevant. You looked at what the employee got. The fact that, for example, the employer in Wilkins and Rogerson paid Montague Burson £15 is neither here nor there. Lord Diplock begins at page 261, and I think it's fair to say that if Lord Diplock had been deciding Tennant and Smith anew in the 1960s or 70s, he would have decided it differently. But in the end, that I think is apparent from page 263, but in the end, he accepts that he's got to abide by Tennant and Smith, and then he decides, along with Lord Reed and Lord Morris, that the surrenderability is the thing which created money or money's worth. That's at page 264. But what all their lordships agreed with, in my respectful submission in Heaton and Bell, is that in order to say that a person is in receipt of money or money's worth, you have to be able to, you have to show that the employee is in receipt of the money or money's worth, or perhaps some third party to whom he's passed the benefit. The fact that money is paid to a third party is irrelevant. Now here, what you have is the inner house saying all the time, here is the money which is being paid into a trust. It clearly arose from the employment, and we agree it arose from the employment, it clearly did. And that is the money or money's worth. We say, no, it's not money or money's worth in a relevant sense, because it's in the hands of trustees. What does the employee get? He gets the benefit of a trust fund, partly for himself, because he gets a loan, and partly for the benefit of his family, who are entitled to the trust fund at a future date.
I mean, in the passage you cited from the inner house, where they talk about gratuities being taxable,
Yes.
they refer to section 62(2)(b).
Yes.
You emphasise the words by the employee, obtained by the employer in 62(2).
Well, yes, in the, you see,
in a sense makes your
if you look at 62(2)(b), I mean, and say, well, gratuities are taxable, yes, if they're obtained by the employee.
So that's the amount, whatever it is obtained by the employee.
Yes, I mean, it's not very likely, I suppose, in real life, that if something is a gratuity, you would try and pass it to a third party. But it might be quite difficult to do it, because by its nature, you've got no right to pass it. But it's got to be obtained by the employee, yes. Not obtained by someone else. So, in our respectful submission, the upshot of Heaton and Bell is this. First of all, you must examine the contract of employment to see what the employee is entitled to. If he's entitled to something and he arranges for that something to be passed to someone else, he remains taxable on it. And secondly, the fact that if you are entitled to something and you arrange that it's passed to someone else, you, the employee, remain taxable. and there isn't the kind of loophole which at first sight was being suggested existed by the inner house. There may be other possible loopholes, and I'll come back to those later, but there's no simple loophole. If I simply say to my employer, don't pay me, pay Aunt Agatha, that's going to do no good at all. And thirdly, it shows that if an employee is entitled to a benefit, the question of whether it constitutes money or money's worth has to be looked at from the point of view of the employee. Can he turn it into money or money's worth? The fact that money is paid to a third party is something one doesn't look at. Now, Heaton and Bell rests, or some of the principles.
In a sense, the question of what happens if it's paid to another party doesn't really arise in Heaton and Bell, as Lord Hodge says. To try and draw conclusions about what happens about money or benefits paid to third parties from Heaton and Bell, it can be a bit dangerous, can't it? Because Heaton and Bell...
Lord, I'm sorry, I'm not hearing a lot.
My fault, I was leaning back, sorry. I was saying, really picking up a point Lord Hodge has already made, that drawing any conclusion about payments to third parties from Heaton and Bell, i.e. parties other than the employee, must be a bit dangerous, because Heaton and Bell was only concerned with a case involving payments to benefits allegedly given to the employee. I mean, the payments to third parties were of a very different nature. They were there to enable the employee to enjoy the benefit. They were slightly different from the sort of payments to third parties we're talking about here, weren't they?
Well, yes, but the Lord, I mean, it could well have been a payment to a discretionary fund for the employee's family. Now, you may say, well, the employee's enjoyment of that is only indirect. He's got the pleasure of knowing that his family is being looked after. But in my submission, that doesn't alter the principle.
But as I understand it...
Sorry, no, please. I was just going to say that the payments made by the employer were under entirely separate res inter alias acta sort of contract with the provider of the motor car and petrol and so on. They were not a voluntary payment, as it were, made to, or a payment made direct to a third party in the same way as we're talking about here. I'm sorry, Lord Hodge was going to say something.
No, can I go back to your Aunt Agatha point? You said there's no loop, because if the employee says, don't pay me, pay Aunt Agatha, that is on the hypothesis that the employee has the right in contract to the sum in the first place.
That's what I was assuming, my Lord.
Yes. Well, let us assume that he negotiates with his employer at the outset that he gets, instead of getting 50,000, he gets 25,000 and Aunt Agatha gets 25,000. On your model, 25,000 escapes the tax net.
Well, I would say to that, if I were the first tier tax tribunal looking at it, I would really begin to ask a few questions about how it was that the employee persuaded the employer to do it. And of course, the result might well be an admission that the employee could well have taken the 50,000. He effectively had exercised rights over the 25,000 and made sure it was given to Aunt Agatha.
Well, let's assume, as here, you found on the take it or leave it nature of the offer by Rangers Football Club.
Yes.
You say that that's what you get. Let's say my employer said to me, I'm not willing to pay you £50,000, but I'll give you 25 and I'll give your Aunt Agatha 25. In that context, Aunt Agatha's 25 would escape tax.
If the employer had some reason for, I mean, whether he had some reason, it would be a strange transaction if he didn't have some reason for paying 25,000.
Well, he might avoid PAYE and national insurance contributions, for example.
Or it might create a series of annual payments in favour of Aunt Agatha if you didn't do anything in return, which might be taxed rather more severely. So it wouldn't necessarily be a transaction which escaped tax. I mean, all sorts of other possible liabilities could arise.
But as a matter of principle, though,
Well, if the truth was that this payment was made to Aunt Agatha, wholly regardless of whether our employee, who was on £25,000 a year, regardless of sorry, I lost track. He had to work for £25,000, and that was his obligation. And the employer, for some reason, said, I want to pay Aunt Agatha £25,000. If that really was the situation, and it wasn't part of some bargain which the employee had made with the employer, at first sight, I think one would have to say Aunt Agatha is not receiving employment income.
but let us assume that
Yes,
let us assume that the parties agree, for whatever reason, and the employer says, well, that's the only basis I'm going to pay you. In return for your services, I will pay you £25,000 and I'll pay your Aunt Agatha £25,000. Assume that the employee hasn't initiated the
Yes.
transfer to Aunt Agatha, and assume that it is a reward for his work as an employee. What then?
I think if one assumes that you're asking me to assume that the £25,000 to Aunt Agatha is conditional on the employee working for £25,000, so the two are intertwined. Yes. In that situation, I would have thought the analysis really should be that despite the appearances, effectively, the employee has procured this to happen. I mean, the idea that it should happen solely at the instigation of the employer, it's so odd that one would say that can't be the real facts. Now, if the real facts are that the employee has said, this is what I want, then that's a different matter. And then I think Aunt Agatha could well find, or rather the employee could find, that he was taxable.
Well, I won't press the hypothesis further, thank you.
But then you see in this case, one's got to ask, is this the same? And the answer is no, because the trust fund is not like Aunt Agatha, not some entirely separate third party. It's an entity which exists for the employee's benefit. It's another way of extracting enjoyment from one's position as an employee.
And if we have Lord Hodges' question reformulated, instead of Aunt Agatha, it's his wife, the employee's wife, or the employee's husband.
Well, then, of course,
then it would be different.
Yes, but my Lord, there, of course, the practical answer is you wouldn't stand a chance of working because it would be a benefit in kind.
Right.
I mean, in any close family situation, that example is never going to arise practically because it won't work.
Yeah.
And if Aunt Agatha is a, so to speak, real stranger, in my respectful submission, the transaction cries out for a bit of further analysis.
Could you just explain to me, as a relative newcomer to this area of the law, why a payment to the wife is a benefit in kind? Is it because it's assumed that's valuable to the husband?
Yes. And there's a definition of family. It's family that is the relevant point.
There is actually a statutory provision.
Oh yes. It goes back to 1948. That was the first time when benefits in kind were brought into charge. Initially, it was company employments. Then it got wider and wider. But it's always been a question of expense being incurred for the benefit of, and then the major point is family and dependents, and that's defined.
Where does one find that now?
You find it now, we'll come to it in due course when we get to benefits in kind, but it's section 202. That's the general benefit in kind charge.
And does it exclude discretionary trusts for family members?
Well, not necessarily. If payments go into a discretionary trust, they may not be benefits in kind at the time when they go in, but they can be benefits in kind when they come out. Now, that's a point that's dealt with in a case called Dextra before the Special Commissioners, which I will come to in a moment.
Yes.
It's of some significance, I think, in Dextra that it was said it's not the money going into the trust that's a benefit in kind. You've got to look at actual benefits coming out. Otherwise, you could have multiple taxation. You could have tax liability on the money going in and a further tax liability when it came out. So, yes, in principle, money going into a discretionary trust can give rise to a benefit in kind.
And do I understand that the actual background in this case it isn't simply out of the blue, the footballer saying, I want you to pay so much to me and so much should be by way of contributions into a discretionary trust.
Yes.
It's rather that the negotiations that take place before he signs for the club are conducted on the basis of net earnings, and in order to be able to pay the level of net earnings sought, or to maximise the net earnings that it can afford to pay, the club has taken advantage of this type of arrangement as being tax efficient.
Yes, I think, Lord, that is a perfectly fair description. But of course, at the end result, we say, is you've got to look at the end result. The end result is they took so much in salary, which was taxable. No doubt they could live on that. And then the rest, they said, that put it into this trust, because if it's not taxable, it's the best deal we can do to achieve the kind of net figure that you've got in mind. Yes. Now, I was going to say that Heaton and Bell did depend on some earlier cases. One is Smith and Stretton, which is a Dulwich schoolmaster's case. I'll refer to that case very shortly,
Right.
and then pass on. It's and I lost it. Yes, it's Volume 2 of the Authorities, tab 18, or MS 1792.
Thank you.
It's best taken up in my submission if one goes to page 38, which is MS 1794, because that sets out how the scheme worked. It starts unpromisingly from the schoolmaster's point of view, because your lordship sees at paragraph 1 that the following increase of salaries shall be granted, so that their salaries were increased. And then the various increases are set out. I don't think your lordship need be detained by how they all worked. And on the next page, your lordship sees at paragraph 3, all assistant masters have got to join a fund. They become members of a fund. And then on the 4, the increases of salary are not paid to the masters, but are retained and put in this provident fund. And then 5, according to how long you served, you get benefits out of the fund. And the question was, were the amounts going into the fund taxable as emoluments of the masters? And not surprisingly, the answer is yes, because they were entitled to the salaries, but had agreed that they be dealt with in a certain way. And one can pick it up, I think, Mr. Justice Channels begins at page 41, MS 1797. He says 4 or 5 lines down, here is a scheme established by the governors of Dulwich College, and the question is whether the true effect of that scheme is to increase the salaries of the assistant masters, imposing at the same time an obligation upon them to deal with a portion of the increased salaries in a certain way, whether that is a true effect of the scheme, or whether the true effect of the scheme, when you look at the substance of it, is not really to increase the salaries, but to give the masters, upon their ceasing to hold the position of assistant masters, gratuities or allowances. Then over the page, at page 42, at the last break in the page, he refers to a case of Bell and Gribble, or Hudson and Gribble, for the proposition that a sum receivable by way of salary or wages is not less salary or wages taxable because for some reason or another the person who receives it has not got the full right to apply it just as he likes. And then if I go to page 44, MS 1800, there are no breaks on that page, but about 2/3 of the way down, does your lordship see a sentence, I think under the circumstances?
Beginning with the word, line begins with the word pose, yeah.
Yes, that's really the heart of it. I think under the circumstances, I'm bound to hold that this scheme really meant what it said, that it did mean to increase the salaries and to provide that as to one portion of the increase, the assistant masters should have it in any event. All the clauses show that as to the first 5%, the masters were to have it, all their representatives were to have it if they died, and so forth. Then he, over the page, on page 45, he considers the other benefits which came out of the fund, but in the end, and I don't think I need to read it, he says that in the end, they're really all purchased by the payment out of the salaries. It's like paying a premium. And so the salaries were applied in paying a premium, and therefore the additions to the salary were taxable on the masters. So I don't think I need read more of it than that. That was one of the cases which preceded Eaton and Bell, and I've already mentioned Wilkins and Rogerson, so I won't say more on that. What I will say is, and this is in my submission of some importance, the principle of Heaton and Bell has been widely employed in the practice of salary sacrifice, where an employee says, I would like my salary please to be reduced, so I don't want to be entitled to it anymore, and I would like benefits in kind to be given to me instead. And what I would say to your lordship, this is entirely uncontroversial and is well recognised, and for completeness' sake, if your lordship wants to see it, in volume 4 of the authorities at MS 2942, you can see how in HMRC manuals the practice is given very, very wide currency. In fact, you're told how to do it.
Thank you.
Of course, now if you go to 2942, you see there EIM 42750, and it refers to section 62 of ITEPA, the definition of earnings. And if I can ask you just to read the 3 short paragraphs there.
Thank you. Yes.
And what is quite clear in my submission is that it recognised that if you do reduce your salary and you get payments for childcare vouchers, which happen to be highly tax efficient, that isn't earnings. That's why it's being done. It's said against us, oh, well, this case doesn't involve salary sacrifice. Well, of course it doesn't, because the employee in this case never sacrificed any salary. He bargained not to have a lesser salary from day one. But that's a distinction without a difference.
But is this consistent with the revenue making effectively a concession rather than saying what the law is?
I'm sorry, my Lord.
Is this consistent with the revenue simply making a concession? Or even if it isn't, the fact that they say this is the law, so what?
Well, yes, you can see that later on, if I take you to one further passage, it's not a concession. They regard it as a law.
Yeah, but even if they regard it as a law, they don't make the law, we do.
Oh, I agree. All right. Well, Your Lordship's perfectly entitled to say that. I mean, of course, this doesn't represent the law, but it is worth pointing out that it is perfectly clear endorsement of the principle.
I see.
Now, if it is said, well, show me some law which recognises this is the correct, the answer is look at the current finance bill. Right. Because it actually deals with salary sacrifice.
Let us be clear, this passage says what a salary sacrifice is. It doesn't say what the consequences are. Do we assume that there's no
I
tax?
think it does say what the consequences are. Sorry, may I just turn back to it? So I probably
Page 2942.
It does, 2946.
Yes, if you go to the next passage, I was going to ask you to look at, which is 2755. It makes it quite clear what the consequences are.
2755.
2755, that's MS 2946. You see, it says, if you look at the longer, the paragraph beginning, if the employment contract is varied effectively, that's to say the person ceases to be entitled, the employee is liable to income tax and NICs on the elements of the new package, i.e. the lower package, the lower cash salary wages earnings, and if non-cash benefits are provided to the employee, the cash equivalent is charged to income tax under the benefits code, but of course in some cases the benefits code won't apply, so the total tax bill will come down.
I mean, so that's really an application of, you would say, of Heaton and Bell, that you've got perks, you've got your tax, you've got your earnings, and you've got your perks, which are dealt with separately.
Well, what you've done is reduced your salary in return for a perk, and if the perk is taxed more beneficially than the salary, you win.
Yes.
Yes, that's what I was saying earlier about Heaton and Bell. It's about which box is the taxpayer putting his emoluments into. But
and we see below a list of the sort of things that are encouraged by way of being exempt from income tax, such as childcare vouchers and workplace nurseries.
And these are specific statutory exemptions for things like childcare vouchers and so on.
Well, I mean, it depends. I mean, if I do a salary sacrifice and take a benefit, the question then arises how that benefit is taxed. Sometimes, if it's childcare vouchers, they're not taxed at all. If it's a car, you get taxed.
Yes, but as my Lord says, it's really about which box it goes into, and either it goes into a box which is taxable or it goes into a box which is not taxable because of some special provision.
Yes.
So it's not particularly controversial.
If you said instead, I'll reduce my salary and I would like a payment to go into a discretionary trust for my family, that actually would be quite a good thing to do because, or it would have been until the law was altered in 2011, because you would argue there was no immediate benefit in kind and you'd only pay tax when the money came out of the trust. Yeah. And we would submit, it's no different here, except that the employee here made the arrangement ab initio. He didn't go out later and sacrifice part of his salary. He did it straight away. It's the same thing. And as I say, in the current finance bill, of course I have to take the point that it's not law yet, but if you look at the drafting of it, it gives clear recognition to the principle enshrined in the manuals. And this is, I'm afraid, somewhere lying on the table is a little black volume.
Yes, we have it, thank you.
Contains, I'm afraid it was missed out, the relevant stuff. It's divider 4, and I apologise for this. It's, I hope, not too complex. If you go to divider 4 and page 2, it says Clause 2 of the Finance Bill, Schedule 2 contains provisions about optional remuneration arrangements. So one goes to Schedule 2, which is actually page 100, a little later, and you see there that there's an amendment to ETEPA, Section 69A, optional remuneration arrangements. And we find that for the purposes of the Benefits Code, a benefit provided for an employee...
Sorry, I'm not, which page are you on?
Page 100 of...
It's page 4 at the bottom.
It's page 4 at the bottom. Sorry, it depends where you look.
Sorry, again.
Page 4 on the bottom left-hand corner.
69A, we have the new 69A.
Yeah.
There's a reference to optional remuneration arrangements, and they are provided if the arrangements are of type A or B. Now, type A arrangements are arrangements under which, in return for the benefit, the employee gives up the right or a future right to receive an amount of earnings within Chapter 1 of Part 3. That's salary sacrifice. Then we have type B arrangements, are arrangements other than type A arrangements, under which the employee agrees to be provided with a benefit rather than an amount of earnings within Chapter 1. That's more akin to the current arrangements because there was no salary sacrifice in this case.
So one's what they were entitled to and they give some of it up in return for something else, and the other is what they originally agreed to.
Yes, yes, that's right. Well, if they've given up something, it's type A.
That's what I meant.
If they say from the start, we don't want the salary,
that's just what
then
I
it's
said
B.
to you, yes.
But it doesn't matter which it is because the consequence is the same. You then have to find out the amount foregone in 69B, and it's the amount foregone in relation to a benefit provided to an employee under optional remuneration arrangements means the amount of earnings mentioned in subsection 2 or 3 of 69A. In other words, you go back to the definition of type A and type B arrangements. Now, how this operates is clear. If you go to page 101 or page 5 and take cash voucher at the top of the page, in section 81, benefit of cash voucher treated as earnings, after subsection 1, insert, where a cash voucher to which this chapter applies is provided pursuant to optional remuneration arrangements, subsection 1, which is a normal charging provision, doesn't apply, and the relevant amount is to be treated as earnings from the employment for the tax year in which the voucher is received by the employee. And the relevant amount in 1B is the greater of the cash equivalent and the amount foregone. So what this is doing, and I apologize for the complexity, is bringing into charge the amount foregone if it exceeds the cost of providing the benefit. But even then, this is all done under the Benefits Code. In other words, they're not earnings, they're benefits which are treated as earnings. So this Schedule 2 acknowledges the existence of salary sacrifice, that's type A, or type B arrangements. It's agreeing that they're effective and then undoing their effect in certain cases. I think what it's really aimed at is the case where, in return for the reduction in salary, the cost of the benefit that's provided instead is less than the amount of the salary because everyone's benefiting perhaps from a better basis of taxation, and so the amount foregone is brought into charge. But all that has to be done, especially, not under earnings, but under the benefit in kind legislation, because if you have a type B arrangement, where you agree to be provided with a benefit rather than an amount of earnings, the amount that you give up is not earnings. You never get it. You're not entitled to it. And that's all consistent with Heaton and Bell, and it's consistent with the salary sacrifice rules that I've pointed out in the manuals. Now, that's the end of my passage on Heaton and Bell, which is the longest passage. I was now going to refer to other cases, section 5, because one asks the question, what were the authorities which influenced the inner house to conclude that entitlement was unnecessary? And to see that, one goes back to the inner house.
Yep.
And we need to go to the reference to Hadley, which is in paragraph 53 at MS 201.
Yes.
Now, this case was relied on heavily. It's a Privy Council case. I think I argued it, actually. It's to do with New Zealand tax law. And Mr. Hadley, who I think was the brother of a New Zealand fast bowler, in case that was a query that someone would like an answer to, was a partner in Pete Marwick, and he'd assigned part of his partnership interest to a company owned by a family trust. And in essence, the question was, did it work? Now, the answer under New Zealand law was that it didn't work. But the question is, here is a case on what would be, in the old days, Schedule D Case 2 income of a profession. Does it have any relevance to United Kingdom law on emoluments and earnings? And in my submission, it doesn't for a number of reasons. But first of all, I should take you to the report of Hadley. It's volume 2, tab 27, or MS 1984.
Thank you.
And the first point I make about the case is that you can see how the New Zealand tax charge works. If you were to go to page 530, that's MS 1990,
Yes.
and if you go just above the letter F, Lord Johnsey says, in order to understand the reasoning of Chief Justice Eichelbaum and the Court of Appeal, necessary to refer briefly to certain sections of the Income Tax Act 1976, which is the principal charging section, and it provides for the payment of income tax by every person on all income derived by him during the year for which it's taxable. I point out first that this is completely different from the United Kingdom tax charge because it's a charge on persons. It was Lord Macnaghten who said income tax, if may be pardoned for saying so, is a tax on income. But what he meant, or one of the points he was making, was that the tax charge under United Kingdom law is not on persons, it's on income. And it's only when you've found the income that you then have to identify who the persons chargeable are. I can give an example of that if it would help, if your Lordship would look at volume 1 of the authorities at MS 1201.
Yep.
Which is part of ICTA
Yes.
1988. And the point I had in mind is that, I can find it, I have lost it now. There is a reference there to section 59.
Yes.
I can't find it now.
12.
Oh, yes, I can. It's 59, persons chargeable. So there you have a very good example. You've got the charge to tax under Schedule D elsewhere. That doesn't tell you, or even start to tell you, who the person chargeable is. And then you find the person chargeable is the person receiving or entitled to the income. One look at that, I think, would show your Lordship that if Mr. Hadley's case had been heard in the United Kingdom, there might have been rather a different result, because the persons entitled to the income, not the person necessarily who derived the income, were or was the company owned by Mr. Hadley's trustees. It's difficult, therefore, in my submission, to go from this New Zealand case to the United Kingdom. But quite apart from that,
That's the Schedule D provision that you're referring to.
I'm so sorry.
If Section 59 is the Schedule D
Schedule
provision.
D. But they're similar. I don't want to burden your lordships with lots of references, but if one goes back through ICTA and its predecessors, there are numerous sections which spell out the persons chargeable. And quite apart from that, if one goes to page 531 of the report, it is evident that there was a principle of New Zealand law, which is exemplified by the case of Spratt. No taxpayer can, by way of assignment, escape assessment of tax on income resulting from his personal activities. Such income always remains truly his income and is derived by him irrespective of the method he may adopt to dispose of it. Well, that's a principle of New Zealand law. Interestingly, if you go down the page to G, you see a reference to the Commissioner of Taxation of the Commonwealth of Australia, and you find that if it was a matter of Australian law, Mr. Hadley would have succeeded, which only goes to show it depends what jurisdiction you're in if points like this arise. And for completeness' sake, I would ask your lordships to look very quickly at volume 3, tab 50, which is MS 2451. This is the John Lewis case.
Yes.
And it concerned a 5-year assignment of rent. If you look at the head note, you see JLP was the property holding company for a group of companies. It owned freehold, long leasehold interests. It entered into an agreement with a Dutch bank pursuant to which it assigned to the bank by deed the right to receive rents payable by John Lewis in respect of properties for a 5-year period. And it was held there that that assignment did succeed, but the interesting point is that if you go to Mr. Justice Lightman, who at paragraph 29, that's MS 2470, there's reference to the Australian authorities. And you can see from paragraph 32, the next page, the principle reached in Australia, namely that the income character of income sold for a lump sum attaches to the lump sum, is in total conflict with the view expressed by Lord Romer. Now, what was the view expressed by Lord Romer? It's at paragraph 25, it was his decision, his speech in Paget, which is a UK case, where Miss Paget sold some income bonds, and it was held that the proceeds of sale were capital. So what one has, and here are cases all actually on this same question of transfers of rights to income. And you can see, I think, fairly clearly from Hadley that in New Zealand and Australia, the matter would have been decided differently. And then you see in the John Lewis case that even the Australian authorities are not followed in the United Kingdom. Really, to base the whole decision on Hadley, my submission, is fundamentally misconceived. You can't transplant jurisprudence in the tax world in that way. And finally, I would say this as regards Hadley. Of course, no one doubted that what was transferred in Hadley was the right to the profits of a partnership. That was what was assigned. I mean, that was income. No one could doubt it was income. Of course, the question here, in this case, is not quite the same, because the question you have to consider is whether the money which went to the trustees and into the subtrust was income, was emoluments or earnings. And of course, Hadley doesn't answer that question at all. The second case that was relied on was Brumby and Milner. And you see that in going back to the core bundle, MS 202. I don't ask your lordships to look at that case because it's clearly irrelevant. In Brumby and Milner, it was decided that money coming out of an employee benefit trust, actually coming out and paid to an employee, was earnings or emoluments. But I mean, no one ever doubts that. In this case, if you asked, was the money paid to the trust money which derived from the employee's work? Obviously it is. But that's not the point. If the question is, does it constitute earnings or emoluments? And then the third case relied on was Smith and Stretton, which your lordships already looked at. That's referred to at paragraph 55. It is noticeable that in referring to Smith and Stretton, the quotation from Mr. Justice Channell, which is in the middle of a page, is a sum receivable by way of salary or wages, is not the less salary or wages, etc. Well, of course, if it's receivable, we would all agree. The question is if it's not receivable. So, in our respectful submission, those principles, those cases don't establish what is the most important point, that entitlement is irrelevant. Other cases were referred to. If one goes further on after paragraph 62, or rather at the end of paragraph 62, there's a reference to Ford and McHugh, and that case is then looked at in more detail in paragraph 67 on MS 211.
Page.
Now, yes. If I could take your lordship to Ford and McHugh, it's MS 2106. It's tab 33 in the authorities, so it's volume 2, tab 33. My Lord Hodge will need no reminding that the headnote makes it clear. A company set up an unapproved retirement benefit scheme for employees by way of a trust, and the company made a contribution in the form of cash and treasury stock for the benefit of the director.
2106.
I'm so sorry, 2106. I do apologise.
I think I'm the only one relying solely on the screen, but I do need the...
Yes, I'm hopeless with screens, so I'm all paper, but it's 2106. So this was a payment of cash and contribution of stock to an unapproved retirement benefit scheme. And then if one goes to, first of all, paragraph 20, it is, of course, correct to point out that there was no argument. I've lost it now. Oh, yes, there was no argument in paragraph 20. No argument was advanced as to whether a payment into a pension or bonus fund might properly be analysed as a payment out of the earner's salary, as in Smith and Stretton. So that point wasn't argued. So what one effectively had, therefore, was a payment to which the employee was not entitled and which went into a pension fund. Now, that was held not to be earnings for NIC purposes, and the first point I would draw your lordship's attention to is that the concept of earnings for NIC purposes is wider than it is for income tax purposes. That becomes clear if one goes to paragraph 6 just below the letter B. In short, Mr. Bramwell accepted that earnings had a wider meaning than emoluments in income tax legislation. And that's explained in paragraph 11, that for earnings in NIC included certain benefits in kind. And then your Lordship's House Court decided that the payment wasn't earnings, and at paragraph 16, 3 reasons are given. The first and principal reason is that the ordinary man on the underground would consider it to be counterintuitive that a person would earn remuneration both when his employer paid money into a trust to create a fund for his benefit, and again when at a later date that trust fund was paid out to him. And I pause there to say, if one looks at the loan rules, there are plenty of possible later charges to income tax. If money goes into a trust, loans are made and loans are later released. So that there was certainly a possibility of a double tax charge here. Secondly, paragraph 17, it's only by looking exclusively to what was paid and ignoring what the earner received that the revenues view can be sustained. But such an interpretation of section 6 denudes the word earnings of any meaning, so that the phrase earnings are paid would amount to payments are made. Well, in my respectful submission, the same point can arise here. In fact, it arises in some ways more forcibly, because the charge to earnings under ITEPA is a charge on the receipt of earnings. If I can make that point good. I do so, perhaps it's not necessary for your lordships to turn it up, but it's section 15 of ITEPA at MS 1285. What is brought into charge are the full amount of any general earnings within subsection 1 which are received in a tax year. So receipt is important for income tax just as it is for NIC purposes.
But received by whom? 15.2 talks about earnings being received, and the person liable to tax in 13.2 isn't the recipient, but is the person to whose employment the earnings relate. So there is, as you conceded earlier, there is no express provision in ITEPA which says that the employee has to be the recipient of the earnings.
But the employee is the person who's taxed. That's section 13, I think.
13.2, but they don't say the employee who received the sums. They say the person to whose employment the earnings relate.
Yes, your lordship's reading, I'm sorry, I've lost the passage which your lordship was reading to.
MS 1283,
MS
the identification of the person liable to tax.
Section 15 of TEP.
13.2 of ITEPA and
Yes.
page 1283.
15.2 doesn't say received by whom, that's the point, isn't it?
Yes.
13.2 tells you the person who is taxable, but 15.2 doesn't tell you who has to receive it.
No, it doesn't, no. But it doesn't, but it is, what we say is it's really all there in Heaton and Bell. If the employee is entitled and passes the entitlement to a third party who receives, then the employee is taxable. But he's not taxable if he wasn't entitled to it.
Can I just be clear? I mean, on that paragraph 17, which is not based on a different provision, my lord is treating earnings as having a meaning which actually points you to what the employee obtains from his employment. So in a sense, that's said to be implicit in the word earnings, as I
Yes,
understand it.
and I mean,
Here we're dealing with a different provision in section 62 of the 2003 Act, where earnings is defined as meaning any salary, wages or fee, and then as going on to gratuities obtained by the employee.
yes, but I mean...
Now, do you say that the words salary, wages or fee have the same sort of implication as the word earnings in the national insurance legislation?
Well, I would say this, that, I mean, the draftsman starts from simple enough proposition, which is, in fact, I thought Lord Hodges' proposition in Ford and McHugh, that the natural interpretation of salary, wages, etc., is that there's something that's coming to the employee.
Yeah.
When you see in the definition of earnings in section 62, any gratuity or other profit or incidental benefit in any kind obtained by the employee, that's saying, well, it's the same principle. It's got to be obtained by the employee. And so we say it's obtained by the employee if he makes use of his entitlement and passes it to someone else, but not if...
But you would say that the same is implicit in A, any
yes.
salary, wages or
Yes.
fee.
Well, it would be very odd in my submission if the two didn't ride together.
But what about C?
Yeah.
Anything else
that's-
which constitutes an emolument of the employment?
Well, yes, but that's put, as I think the note said, that was put in just in case. I mean, I don't think anyone had anything particularly in mind, but the draftsman thought, well, I might have missed something out, so I better put those words in just to make sure. But, I mean, the notes say that. The
Yes,
notes
but
say,
it-
we're not sure we've covered everything, so just in case we haven't, we've put in C. But I would say,
do we
well,
interpret?
C, I mean, would follow, it would be very odd if C, for example, meant that it could be things obtained by someone else.
But C might cover the unlikely benefit to Aunt Agatha.
Yes, I mean, that is conceivable, yes. I mean, of course, one is troubled by the Aunt Agatha example if it's the example where there's no prior entitlement. I mean, where there's entitlement, we say there's no loophole
Yes,
at all. I accept that one ought to be troubled by the example where the employee exercises no control over the employer, and the employer, for some obscure reason, decides to pay Aunt Agatha. I mean, one's instinct is, well, look, I mean, this is pretty odd. There must be something in the legislation somewhere which copes with it, but I would say to your lordship, that's all right, that this Aunt Agatha case is really a bit of a peculiar one on its own. We're dealing with benefits to the employee here, not some obscure recipient who appears to have nothing whatever to do with the employee.
Can I just, bring us back to sort of where we're at the statutes. If one compares section 62 with its predecessor, section 131 of ICTA,
Yes.
you get, one can see the pattern, and you had all on page MS 1202, you had salaries, fees, wages, perquisites, and profits whatsoever.
Yes.
In 62, you get salaries, wages, and fee in A. You get the perks as interpreted in Tennant
Yes,
Smith
I think it's
in
clear from
B,
the notes that
and then
B-
the profits whatsoever in C.
Yeah, B is dealing with perquisites.
Yes, of course.
And it is worth bearing...
But the point I'm putting to is there was a residual category of profits whatsoever, which one can see the draftsman thought he'd better pick up under C.
Yes.
But is there any guidance of what is meant by profits whatsoever in the sort of 100 years
Well, I don't
or
think
so
there
that
is.
it-
I can't think of any.
on
I
the
mean, I
statute
think the notes themselves make clear that the draftsman didn't have anything in mind,
No.
but he thought I might have missed something out, so just in case.
But as far as you recall, in the 100 or more years that profits whatsoever has been on the statute book, there's no guidance as to what it means.
I can't think of any at the moment. I'll keep thinking, my lord. I might perhaps...
I suspect if you can't, I doubt if anyone else will be able to.
Yes, I'll see if I get any assistance on the point, but I have a suspicion there isn't anything.
No.
Going back to Ford and McHugh, I make 2 points, really. One is, if one looks at the inner house and what they deal with, what they say about Ford and McHugh, one finds that they make, if I remember rightly, 2 points. The first one, yes, it's paragraph 69 at MS 213. In the first place, they say, Ford and McHugh is concerned primarily with liability to NICs rather than income tax. But if I might respectfully say so, that's hardly a factor which helps to distinguish it, because if earnings for NIC purposes is wider than it is for income tax purposes. Surely it would be rather surprising if something were earnings for income tax but not for NIC. And the second point is the double taxation point, which comes in the middle.
Yep.
And
That was the main reason for Lord Hodges, for our conclusion, for Lord
yes,
Hodges'
but
judgment.
all I would say on that is if the assumption of Vienna House is that if tax is paid going in, it won't be paid when going out. I'm not sure that that assumption can be quite so certainly entertained. The legislation which certainly now exists on employee benefit trusts would impose a tax charge, but I suppose it's unfair to bring that in. But it may be said, well, if an employee puts money into an employee benefit trust, does it necessarily follow that it's not taxable when it comes out? It might be, it might not be. There's no case on the subject, as far as I'm aware. There's no case where the employee has borne tax on the money going in. Now,
Yep.
the third point comes in paragraph 70. I don't think I need to take up any time on that one.
Right.
There's only one other case, really, which is a significant one, which is paragraph 72. They do deal with Heaton and Bell, but
Yes.
there's no question of looking at the contractual entitlements.
Did you want to look at
Paragraph 74,
Yep.
I can pass over the Collins case.
Right.
They do look at Dextra accessories, but the point which is missed, which in my respectful submission is the important one, is that precisely the point that your lordships have before you now did arise before the special commissioners in Dextra. I can show that to the court, I think, very quickly. I've lost the authority this time. Oh yes, it's
The Special Commissioners at 2039, tab 29.
yes, just a minute.
That's Dr. Avery Jones, is that right?
Lost it.
Or is it the other Dextra?
No, is it A2, tab 29?
Oh yes. What volume 2?
Volume 2,
Tab.
29.
Cool. Yeah. Yes. Dextra at 2039.
Yep.
Now, the special, your lordship, my lord, Lord Hodge,
I will remember it well. I got it
you'll
wrong.
remember the
didn't I?
case.
Yep.
And what your lordship didn't have to decide was the earnings point,
Probably just as well. I probably got that wrong too.
which came up before Dr. Avery Jones.
Yeah.
And you can see his decision on earnings.
Yep.
It starts at paragraph 14 at 2044.
Right.
And you can see that what happened in this case was money went into a trust in December and was subjected to sub-trusts in March. So the sub-trust didn't come out immediately. The sub-trusts in March 2045, just above the letter H, on the 10th of March 1999. And these were sub-trusts for the benefit of employees and their families.
Yep.
You see that loans were made if you go to page 2046 at the letter 9. And then we come to paragraph 15 on page 2047 in contending that the sub-funds are to be treated as the property of the beneficiaries. Your lordship can see it's a very similar point to the instant case. All sorts of facts were relied on by Mr. Brennan for the revenue. And at paragraph 16, Mr. Brennan requests us, this is 2048, to make a finding from these points that the money contributed by the group to the EBT trustee was at their absolute disposal. And they say we don't consider such a finding would be justified. And then a little between H and J, they say, in order for the funds to be in the unfettered control of the sixth, the trustee must exercise its discretion and take further action of appointing those funds absolutely to the beneficiaries. And they say eventually that it simply wasn't the employees' money. And I just lost the passage where they say that. Can you find it? Para what? I'm so sorry, I've lost the...
Paragraph
Oh,
17.
here we are. It's
Paragraph
on page
17.
17.
Yeah.
The reason, paragraph 70, I'm so sorry, it's staring me in the face, just above the letter C, the reason why the employees are not taxed on the funds and EBT is simply they don't belong to the employees. The six may have carried this to extremes by not taking any significant remuneration in cash, but their position is entirely different from what it would have been if they had. So that was a more extreme case than the present because they took nearly everything in the form of money in sub-trusts. The only other case which I should refer to is Edwards and Roberts, which is in volume 2 at 19.
You say the inner house here simply missed the point.
Well, they didn't mention it.
Because Semper Metals they looked at and they thought it was wrongly decided.
Yes, but...
You say that they'd have had to say that Dexter was wrongly decided.
In Sempra, Mrs. Bryce, the special commissioner, followed Dexter. So really the question is Dexter right?
Yes, well, that's what I thought you might be saying.
Yes.
That logically, they should have treated them both as being wrong.
Well, they just didn't consider or get any help from Dexter because the points they've mentioned were the points that went on when the case went to the House of Lords, which are all on deductibility. Mm. The only forum in which the question of taxability of the employees came was before Dr. Avery Jones.
Did the revenue, did the HMRC take before Dr. Avery Jones the point which they took before the inner house?
So did they take the point?
Did the revenue take before Dr. Avery Jones the point which they took before the inner house, or did they pin their case on the employee having control over the funds? Absolutely.
They didn't take a similar point to the point taken in the inner house, no. I mean, in my submission, the point wasn't takeable, but
No.
Anyway, it wasn't taken.
No.
So finally, we have Edwards and Roberts, which is at divider 19, it's MS 1804. This was the case, if one goes to the head note, it's really quite clear. There was created a conditional fund. If your lordship could read the head note very quickly. Each year, a sum was paid into the conditional fund, and eventually the employee got it.
Yeah.
Now, the employee was arguing that he should have been taxed on the money going into the fund, but the Court of Appeal decided that he was taxable on the money coming out because he wasn't entitled to anything until the money came out. And I think we can pick it up at page 638, MS 1824, which is Lord Hanworth. Halfway down the page, he says, that being so, it appears to me it would be wrong to treat this case as coming within the principle of Smith and Stretton. The principle, no doubt, is quite clear and illustrated by the decision in that case. So, pausing there, the judge in the High Court has said it was covered by Smith and Stretton. It seems to me that the facts in this case stand apart from that principle, and that under these circumstances, there could not be said to have accrued to this employee a vested interest in these successive sums placed to his credit, but only that he had a chance of being paid a sum at the end of 6 years if all went well. So he was taxable on the £1,640 that came out. Lord Justice Roma says something similar at page 640, MS 1826, halfway down the page at the end of his judgment, and Lord Justice Morm agrees. And we say, well, if the taxpayer in Edwards and Roberts had argued his case in the inner house, he would have won, because here was money being paid as part of his salary arrangements, part of his package. Money was being paid into this conditional fund from which he could benefit.
Does it follow then that when it gets paid out, he has to pay tax on it?
Yes. And we say, if the loan is repaid and money is paid out of this trust, there'll almost certainly be tax.
Why almost certainly? Why not certainly?
But why?
Why almost certainly?
Well, there are possibilities. One, that there's an exception from liability if a loan is released on death. That's section 190 of ETEPA. But in most cases, it would be taxable.
Thank you very much.
What did the inner house say about this case?
Well, what they said, I'll come to it now, my Lord, it is
You're hitting the buffers in terms of time.
I've lost the keys. Which chapter?
71.
Oh, it's paragraph 71. It's quite interesting. They said, yes, my learned friend, Mr. Dunlop, who's here at page 48, MS 215, submitted that if HMRC's argument in this case were correct, Edward should have been decided in favour of the taxpayer. And then they say, in our opinion, this doesn't follow. It's important to bear in mind that a critical feature of the Court of Appeal's reasoning was that the taxpayer was not entitled to anything until the lapse of 6 years. Well, we say he wasn't entitled to anything here, and his right could have been entirely defeated if he had, for example, left his employment during that period. In the present case, by contrast, the various trustees became entitled to funds immediately. Well, pausing there, that the entitlement of the trustees is nihil ad rem, we would say. It's the only person you're looking at is the employee, not the trustees. And then to hold them as redirected income of the employee, well, that begs the whole question. The position is the same as that in Smith and Stretton. Well, it's certainly not the same as Smith and Stretton. And as regards Hadley, we say that doesn't apply. So it's clear, in my view, that Edwards and Roberts is a problem, and it's not sufficiently explained, in my submission, by the inner house. Now, that conclusion, in concluding, I say to your lordships, well, first, Eaton and Bell is the most helpful guide.
Yeah.
Secondly, the situation that arises in this case, although it may be a case of marketed tax avoidance, is no different from the situations that arise with employee benefit trusts generally. Finally, it's worth pointing out that there's a Part 7A of ETEPA, which now taxes loans as though they were emoluments or earnings, so the whole scheme has been stopped. And finally, just for completeness' sakes, all these loans in this case were made after 1999, and Schedule 10 of the current finance bill is going to bring them all into charge if they're not repaid by 2019. It's worth, I think, bearing those circumstances in mind. My Lord, I'm very conscious I'm now coming to benefits in kind.
Well, I think you're hitting the buffer in terms of time,
Yes.
aren't you?
I thought I might have 3 minutes because we started a bit late.
Perfectly fair point.
Can I make two short points? First of all, if there is a benefit in kind charge here, it has to be on the benefit of the free loan, because the legislation, both in ICTA and ETEPA, and I can show you the passages later, make it clear that the specific benefit in kind charges take precedence over the general one. Regulation 80 determinations, which are what's appealed against here, don't cover loan benefits because there's no actual payment of anything. They're simply, you're assessed on the notional interest on the loan. So the short answer to the benefit in kind contention is that the general residual charge, which is what my learned friend is trying to pin home, is taken out by the specific charge. And if that is so, that's the end of the matter, full stop. Secondly, I don't concede that the general benefit in kind charge does get home anyhow, because if you look at Dextra, before the passage on emoluments, there's a passage on benefits in kind, where Dr. Avery Jones says you've got to wait till specific benefits come out, not you don't tax payments into a discretionary trust fund. And the third point I make is Lord Doherty refused permission for the benefit in kind point to be raised on appeal to the Court of Session. It never was raised. The application to argue the point was not renewed. So it comes before your lordship without any guidance whatsoever in a rather complicated area of law. And in my submission, it's inappropriate for it to be raised at this late stage. Of course, my learned friend says it's all very simple, but the simplicity is something he wishes to have. I say it doesn't exist. On that short note on benefits in kind, if I may, I shall cease.
Thank you very much indeed, Mr. Thornhill. Mr. Dunlop.
Lord, I'm only responding on protectors and would anticipate addressing the court tomorrow. Bye-bye.
Thank you very much. Mr. Ghosh.
I'm grateful. Please, may I start by asking the court to articulate the issue as follows. What the court should ascertain is, one, looking at both the footballers and the executives, what was the reward payable by the employer to the employees as part of their bargain? That does not entail looking at the reward from exclusively the perspective of employer or employee. What one ascertains is what was the bargain.
So could you say it again, your formulation? What was the reward payable?
By employer to employee as a reward for the work done. There are two candidates in this case. The first candidate is that the payments made to the principal trust were payments of wages, and they were paid to the principal trustee to avoid tax, no other reason. That was the reward. The employees were content with that because they hoped that the salary once paid, it was only paid once, would be applied in a way that they could access the benefit of this tax-free sum. And that, in my respectful submission, is the truth of this matter. There is much less, my lords and my lady, to this case than meets the eye.
I mean, is it essential to that formulation that it was paid to avoid tax? Or is that?
No.
No. So that's just a jury point on the side.
That explains why the employee was content that the money went to someone else who wasn't him.
Yes, but it doesn't change the analysis.
Not at all. The other candidate is that the relevant reward was the hope of a loan which bore interest, rolled up, so long as the principal trust trustee and the sub-trust trustee exercised their discretions in the right way. And that, in my respectful submission, is not a realistic description of the bargain between employer and employee in this case. just to pick up on the exchange between my Lord Hodge and my learned friend, Mr. Thornhill, if you take the Aunt Agatha example, at the outset, this is not a rhetorical question, excuse me, why is it that an employee would be content for the 25,000 on my Lord Hodge's example to be paid to Aunt Agatha? Your Lordships and my lady have this already in my written case. There could be all sorts of reasons. One, I might want to benefit Aunt Agatha. Saves me paying her myself. Two, I might be a favourite nephew, so I rather hope she will give or lend me the money. Doesn't change. That explains why I'm happy that Aunt Agatha gets the money. Doesn't change the quality of the payment made by employer to the third party to Aunt Agatha, if that payment is made as a reward for my work done.
And if Aunt Agatha does lend me the money at no interest, it's unlikely that would be counted as part of my emolument because she lent it, having got it from my employment.
Absolutely not. There has to be a causal connection, and I'll show the court this.
The break in the cause is the hope that she'll lend it, as it were.
Yes.
She's not obliged to.
Absolutely right. Absolutely right. The salary is paid once. Nobody in this case is arguing the salary is paid twice. So it's misleading, I say this respectfully, to make an inter orem submission about multiple tax charges.
So in effect, you each rely on the first point in Lord Hodge's speech in Ford and McHugh for different reasons. You draw different conclusion from it. You say it's taxed when it's paid, doesn't get taxed when the trustee and sub-trustee exercise their discretion.
Exactly right, because, as I say, there is less to this case than meets the eye. What all the authorities say, including Ford and McHugh, in my respectful submission, is that what one has to find out is what is it that's paid, and in respect of what tax year is it paid. So, therefore, you have cases like Smith and Stretton, where an element of the salary was paid compulsorily to trustees and may actually have never reached the employee because it was contingent. If he left employment within a number of years, he would never have got it. Compare and contrast Edwards and Roberts, where, and you weren't shown this, in Edwards and Roberts, the money that was paid into the conditional fund was a percentage of the profits, if any, earned by the company. So what the Court of Appeal was looking at in Edwards and Roberts was payments made by the company of a percentage of its profits, if there were any, and then a contingent interest which only fructified in certain circumstances. So it is not at all surprising. And the subject matter of the reward was at large, because it was a question of whether he got money at the end or the shares. So it is not remotely surprising that the Court of Appeal held, well, in finding out what the reward was in Edwards and Roberts, you can't tell until the end. It was shares.
In the Smith-Smythe case, you say that there was no right to the money paid into the fund because the employee had to remain in employment for a certain period.
That was one element of it.
But the tax didn't become taxable when that condition was satisfied.
The tax point would depend on the rules that applied at that time. So far as this case is concerned, if Smith and Stretton were played out today, the PAYE obligation would bite at the time of payment.
Yes.
So the timing of the tax charge is something which the tax code from time to time will deal with. So far as this case is concerned, the PAYE code bites at the time that the earnings are paid. I'll show the court this.
Thank you.
But there's no question of a double tax charge. And I'll make that good. Because on the primary case for the revenue, there's one payment of salary at the time that the money goes into the principal trust, and everything thereafter is an application of the tax scheme, and an application of that salary as the fructification of the tax scheme. So the causal connection between employment and the payment is spent at the time that the money goes into the principal trust. If I could please just take the facts short, and with the court's permission, I shall simply give references because this is uncontroversial. So far as the facts are concerned, 1, for both footballers and the executives, the payment into the trust rather than the payment to them was discussed with them before the payment. You'll find that at paragraph 103, little Roman 5, page 117, MS 283.
Yep.
As far as footballers were concerned, they were recruited on a single package, where the payroll salary, call it that, and the trust payments were component parts of that single package. Paragraph 11, MS 263, 52, MS 272, 79, MS 277 to 278.
Yeah.
So far as the cash bonuses were concerned to the executives, this scheme simply replaced cash bonuses paid to them. And they were told that the reason for this was to avoid tax. Paragraph 12, MS 264, and as it happens also, paragraph 103, little Roman 5, 283, that applies to footballers and executives alike. Now, the reason I mention that, none of this is controversial, it's all recorded by the first year tribunal. Is that, 1, the payments were payments for work done. We all know that. 2, after prior discussion, that's when the payments went into the principal trust. So that informs the bargain between footballer and executive on the one hand and Rangers, the employer, on the other. It really was, for both of them, nothing more than the footballer saying, or being told, I'll come to take it or leave it in a minute, part of your salary, let's say it's my Lord Hodges 25,000, we're not going to pay you. We're going to put it into the trust. But don't worry, that's a good thing. Because so long as the trustee exercises their discretion in the right way, they'll appoint it onto a sub-trust, and then if the sub-trust trustee exercises its discretion in the right way, you'll get a loan at interest. So far as the executives were concerned, the bargain really was, well, we're thinking of paying you a bonus, and actually, if we decide to pay you a bonus, we're not going to pay you. We'll pay the trust. Again, a good thing. And in my respectful submission, it is a sign, and my learned friend did not directly answer the questions put to him by the court on the Aunt Agatha example. Aunt Agatha and the main trust trustee are the same in this example. I, the employee, am perfectly happy that you pay my Aunt Agatha or the trustee in this case, because I think and I hope, and you're telling me that I hope, that my hope is a good one, that actually once it's paid to them, they will let me access the benefit. That is this case. And when we get to questions of what does the employee receive, what's paid, the real question, as I've said now more than once, what is the bargain between employer and employee? And in my respectful submission, the bargain is your wages, an element of that will be paid into the principal trust because you'll get a bigger benefit. If I could please take the statutory provisions short. It's behind tab 5 of volume 1 of the authorities bundle. And if you could look please at section 19, which is the charge under the Taxes Act 1988, MS 1198. And if the court please looks underneath Schedule E1, where it reads tax under the schedule, if the court has that. Shall be charged in respect of any office or employment on emoluments therefrom. Now that's the connecting factor. It's a causal test. It has to come from the employment. Section 59, which you've already seen, is to do with Schedule D. That extends the tax charge to recipients. That's not relevant to this case. Section 131 you've seen. This is at MS 1202, which simply confirms that tax under Schedule E is charged on the full amount of the emoluments. But just to kill this point about tax is charged on what is received, not what is paid, if the court please looks at section 202 capital A, it's at MS 1216.
Yes.
So 202A tells you that in little 1, income tax is charged under Schedule E on the amounts received. Little b, received. But then if you look at 202B, MS 1218, you're told that emoluments shall be treated as received at the time when, little a, when payment is made, and at b, when a person becomes entitled, and has been pointed out repeatedly, no mention there that it has to be the employee to whom the payment is made. No mention that the person entitled in little b needs to be the employee.
So which is the section which says who's being assessed?
There isn't an equivalent to section 13 in Taxes Act 1988, I don't think, but given that you're told in
section 13.
That's in ITEPA.
As I see.
I think.
Of course, yes, sorry. Yes, yes.
If I could come back to my Lord Conworth for Tax Act 1988, but given that the income, if it's Schedule E income, is subject to PAYE, then actually as it happens in this case, the person assessable is the employer, and it's in respect of the employment.
Yes. Well, I'd be surprised there wasn't something somewhere which said who was...
Well, there might be, and if there is, I'll deliver that to the court. It's section 13 for ITEPA, yes, in any event.
Well, your point is B talks about a person. 202B1B. A person becomes entitled.
Yes.
Whereas C, D and E refer to the holder of the office or employment.
Yeah, exactly right. But these are all in the alternative, as your Lordship can see.
But it's really A, when a payment is made. And you're relying on 202B1A here, the point is when the payment is made. Is that?
I'm simply saying there's no magic in the word received.
No, I see. I see, or any person becomes entitled
Yes.
regardless of
Yes.
who it is.
And as it happens, if I can take this point again short, it's the same analysis which is replicated for ITEPA purposes behind divider 9. I'll simply give the court, with the court's permission, references. Section 9, little 2, talks about earnings from the employment.
Sorry, section 9
Sub 2.
on page,
And that's MS 1278.
yes, that's what I thought, sorry. Yep.
Then section 11 tells you how to calculate net taxable earnings. Section 15, section 13 you've seen, that tells you specifically who's taxable. Section 15 you've seen, because the appellant took you to it. Little 2 talks about earnings being received, but section 18 on MS 1288 replicates 202B. General earnings consisting of money are to be treated for the purpose of this chapter as received at a time when a payment's made, so on and so forth. So it's a short point. There's no magic in the word received, not in terms of the text.
And again, one can contrast a person in Rule 2 with the employee in Rule 3.
Absolutely right. Absolutely right. And please may I finish, because I'm also hitting buffers, but please may I finish by looking at section 62 at MS 1311.
Which we looked at again before, yeah.
Absolutely, but the only point I want to make
I wasn't complaining.
is at little 2, little a, unlike little b, there is no reference to that phrase obtained by the employee.
So you rely on wages, I think, here, don't you?
Yes.
You don't rely on any other emolument under C.
Well, why? I can rely on that too. Why not? But
I just...
but the natural on my don't pay me, pay Aunt Agatha take on this case, it's either A or C. If the court pleases, I can stop there and pick it up again after lunch.
Thank you very much. We'll resume again at 2 o'clock. Court's now adjourned.